Uh, so, okay, so everybody, uh, my name is Attorney Robin McCoy, and I'm president, as you know, of Black Women Lawyers in Michigan. And let me see if I can, oh, I'm right here, boom. So, we've been having speakers come in and talk about different issues. And so I thought it was very important that we have Ms. Tracey Martin come in, who she is an expert in this area of child welfare law. She's been certified. She's a graduate of Detroit Mercy Law School. And I've known her for a number of years. And so I thought it was very important that we have her come in and talk about this subject matter, especially since there's been an issue for me, as long as I've done child welfare law, whether I represented parents or children, there's been this issue about the disparity of treatment of Black children that being caught up in the system. And so I know that Tracey is a fierce advocate for parents, and and making sure that their rights are protected. I've seen her firsthand in the courtroom. And so without further ado, I'm going to turn it over to Ms. Tracey Martin to talk to us about how to handle a child welfare case.
Great. Thank you, Robin, for the great introduction. And I did prepare a PowerPoint presentation. I don't know if I could get co-host privilege just to share my screen.
I just added you. So I just gave you permission or gave you that capability. So you should be able to share your screen.
Okay, let's see if this quickly works. Fantastic. It looks like it does. And I want to apologize right off the bat. I was working with this earlier this week, and the slideshow was working beautifully, but now it is not. So, but you can still see the slides, and I don't know, this might even be better. So I'm just going to advance the slides manually. Unfortunately, you won't see the beautiful transitions, but it still works. The content still works. And so as Madam President McCoy said, I have been practicing child welfare law for a number of years, actually almost 15 years. Prior to that, I was heavily involved in insurance defense litigation, and that's really where I got all of my trial experience, and I performed well over 500 depositions. I always had a dream of going out on my own in a private practice, and something happened in my career and an opportunity to do that developed. And so I went for it, and I specifically selected child welfare law as my specialty. I prepared in advance by attending seminars put on by the Institute of Continuing Legal Education, ICLE, as some people refer to it. And I went down to Lincoln Hall of Justice in Wayne County to shadow attorneys and just, observe and sit in on various matters to see if this was really something that I wanted to do. And I decided to take the plunge. That was back in 2007, 2008. So today for you, I have just a few slides on a presentation that I've called Anatomy of a Child Welfare Matter, from Preliminary Hearing to Disposition. And that's really the crux of kicking off a child welfare case in any jurisdiction in Michigan. I just wanted to relate a few interesting statistics. Child welfare cases are really prevalent in the media today. And I think there is an intersection between child welfare and what we are seeing across America in terms of the child rights movement. And there's an intersectionality with the parental rights or parent rights movement, coupled with or combined with the human rights movement, civil rights, and constitutional rights movements across the United States of America. So there's an interesting study out there by the Human Rights Watch organization and the ACLU that says that 1 in 3 children in America will be part of a child welfare investigation by age 18. That's pretty significant, I believe. And that nearly 8 million children in the United States are referred to a child abuse hotline. Well, that was in 2019. And more than 80% of families or children were found not to have faced abuse or neglect. I should say more than 80% of children were found not to have faced abuse or neglect. So today I'm going to be talking about what leads up to a family's interaction, contact with the courts when it comes to child welfare law, which is heard in family courts in the juvenile sections of courts in the various jurisdictions in Michigan. I'm going to specifically be focusing on the preliminary hearing phase. I'm also going to give you a quick ICWA update. ICWA, that stands for Indian Child Welfare Act. There's something really pivotal happening in the United States Supreme Court regarding ICWA, and it could have interesting and severe consequences when it comes to tribal sovereignty. I myself am I should say genetically a member of the Eastern Band Cherokee tribe. I just missed enrollment. My mother was enrolled, but I am not, but genetically I am. So this is an issue that's very close to my heart. And I'm also going to be talking about the pretrial phase, what needs to be done there, the trial and best interest hearings. Then I'm going to touch on reviews, rehearings, and appeals, and then we'll end with dispositional hearing. So back to these statistics. Taking it to Michigan, in 2008, Michigan had more than 19,000 children in care. As of January 2002, MDHHS, no, that's got to be a typo, I'm sorry. As of 2020, MDHHS says that the number has dropped to 10,000. So there's been a large decrease in children placed in what we call congregate care facilities. More and more children are now being placed in family foster homes. Some people call that relative care or kinship care. I myself am currently serving on the Michigan Department of Health and Human Services Kinship Advisory Council. You might have noticed some ads in the community, the Michigan Chronicle, online, other newspapers that talk about kinship care. And that's great for a child that finds him or herself facing foster care. It's always better to have the child placed with a relative. I know when I was growing up, I actually had cousins who came to live with my family so they could avoid foster care. I mean, there's nothing wrong with foster care, but certainly, you know, if a family member could take the child for temporary care, that's always more, in my view, in my personal view, and I do believe the view of MDHHS, that's superior, that's better because you have that connection with the family, and usually it works out better for the parents who find themselves respondents who are facing a petition, a child welfare petition. So in 2008, Michigan had more than 1,200 children in group facilities compared to about 450 today. So the numbers are dropping. And I can personally attest to that because I remember when I first started practicing child welfare law in Wayne County in 2007, 2008, officially it was 2008, the numbers were up, you know, in terms of the census. And I can tell by caseloads today the numbers are dropping, and the numbers from the courts also indicate that. So there has been a substantial decline in overdue, what they call overdue child protective services investigations. There was a lag at one time regarding suspected child abuse and neglect. In 2019, there were 1,260 of those such cases. And now, well, at the end of 2021, they've dropped to only 22. So that's really significant. And Madam President, Rob McQuay mentioned at the beginning of this talk about the disproportionate impact on Black children. I cite back to Human Rights Watch and the ACLU, American Civil Liberties Union. They prepared a study which indicates that Indigenous children who enter the foster care system do so at nearly double the rate of double the national or nationwide rate, and that Indigenous parents are up to 4 times more likely to have their children taken than non-natives. Also, I wanted to mention another statistic from Human Rights Watch and the ACLU that found that nearly 75% of children who had contact with maltreatment in 2019, they found that 75% of those children were involved in neglect as defined by the child welfare system. So now moving on to the preliminary hearing. And this is an interactive presentation. If anyone has a question at any time, please feel free to jump in. However, there will be time at the end for any Q's and A's if you have any. So the preliminary hearing is what sets this all off. MCR 3.900, that's a special proceedings court rule in Michigan. It used to be MCR 3.965, I believe that numbering has changed, but that sets forth the basic procedures governing a preliminary hearing. And that is the very first court hearing that is held after a child's been removed from his or her home. And the preliminary hearing must commence no later than 24 hours after the child has been taken into protective custody. However, that does exclude days like today, Sundays, and holidays. And so the preliminary hearing is a hearing that can be highly stressful, very emotional, and traumatic. Number one, for the families involved, the child, the children, the families, and frankly, even for the attorneys who are involved in such proceedings, whether they're representing the parents, which typically I do, or they are representing the children, lawyers, guardian ad litem. I have also performed that role in the family court, in the juvenile section. I've performed actually every role imaginable in the juvenile court, except for being a judge, obviously, or a referee, or a prosecutor. I've never worked with the Attorney General's office, but it can be very traumatic, and it could lend itself to secondary trauma among the legal professionals who find themselves involved in such proceedings. And so the first thing that in terms of procedural issues that comes up in a preliminary hearing is notice. And one of the biggest questions is, did the petitioner, which is typically the CPS investigator, did the petitioner notify the parents, the respondent parents, of the date and time of the hearing? And these hearings, I mentioned how traumatic and stressful they can be. They can go at lightning speed as well. If you are an attorney representing a parent, assigned to represent a parent, these hearings go very fast. You don't have very much time to talk with the parent or parents. We're in the Zoom era now, so these proceedings, for the most part, are in Wayne County anyway, are happening on Zoom. I've noticed of late that you get a little bit more time to maybe speak with your new clients because of the way that the matters are spaced out, but not that much. It's not like you're getting 24 hours notice where you can really have a good discussion with your client about the allegations that the parents are facing or the parent is facing. And so regarding a petition, it will either be a temporary custody petition where the court might take temporary jurisdiction of the children or child and make the child a temporary court ward, or the parents could be facing what is called a PC petition or permanent custody petition, where the parents find themselves facing the dreaded termination of parental rights, very serious, and could lend itself to different approaches at the preliminary hearing. So, as the attorney representing the parents, it is the duty of the lawyer to go over the allegations against the parents, and at the preliminary hearing, there is a statutory right to counsel in Michigan, and so lawyers will be appointed to represent the parents, and also lawyers will be appointed to represent the child or children, and that's where the lawyer guardian ad litem comes in. Special consideration for incarcerated parents. If a parent is incarcerated, there is an effort made to get that parent to the hearing, particularly in Wayne County. If the parent is incarcerated in Wayne County, that individual will appear by Zoom. Many times, well, I shouldn't say many times, but sometimes a parent may be incarcerated or confined in a federal prison, and typically the parents will participate telephonically. Or a parent may be incarcerated in a facility in Michigan, and there's a good effort made to get the parent on Zoom. So also, in terms of the petition itself, the court actually has the responsibility of making sure that copies of the petition are served upon the respondent parents. It is actually the court's responsibility, not MDHHS. And so in the Zoom era, what is frequently happening is the petitions are being sent to the lawyers who are like on deck to be assigned to the parents. In Wayne County, they're called emergency house counsels or house counsels. And, using technology, the petitions are emailed to the attorneys, and then hopefully the parents have access to an email address, and the parents oftentimes receive the petitions by email from their own attorneys. And then at the preliminary hearing, the parents are asked if they accept service of the petition via email. They don't have to accept it that way. Certainly, a sheriff's deputy could come out and serve them personally or by mail if they refuse to accept by email, or perhaps they don't have an email address, and the court will make arrangements for that to happen. But service is a very pivotal part of the receipt of that petition. And then we go to formal reading. Oftentimes what happens at the preliminary hearing, the parties will waive the formal reading of the petition. That's where the court will, one by one, read all of the allegations. Typically, the lawyers will have had an opportunity to talk with the parents, and not that much time, but they will have already gone over, for the most part, the allegations. So many attorneys will just, in the interest of time, waive the formal reading. So there was a big case called Sanders, N. Ray Sanders, pre-pandemic. Can't remember the exact year, but it was pre-pandemic and it was pretty pivotal. You know, one time parents were sort of lumped together as one, you know, regardless of whether they were married or not. But because of N. Ray Sanders, you know, parents each have their own individual rights in terms of how they want to proceed with a case. And so what comes up often at the preliminary hearing is there, you know, the question arises, is there a non-respondent parent who may have joint custody or who could possibly take placement of the child? And so if there is, then MDHHS, they will investigate, you know, whether there are any types of custody orders in place. And if the parent is suitable, if they do not, to take placement of the child. I am noticing that there are a lot of petitions these days. I shouldn't say a lot, but a significant number of petitions these days that only have one respondent parent. And the other parent who's a non-respondent typically will take placement of the child, and they will seek a formal custody order from the Domestic Relations Division at front of the court, the front of the court division or section. You know, typically when there is a child welfare proceeding pending at the juvenile section, that stays everything in terms of seeking a guardianship or custody. But lately, well, I've noticed in the past couple of years that parents, they can seek custody of the child if they don't already have a custody order in place, and the family division, the domestic relations division, specifically FOC, they will hear those motions. And there is a new program, relatively new program called the Child Parent Legal Representation Program, CPLR for short. And that is for parents who do not have custody, non-respondent parents who do not have custody. That makes a way for them to seek and potentially gain custody of the child. And that is oftentimes used as a way to resolve the case short of a termination of parental rights. The downside of the CPLR program at Wayne County, though, is I'm noticing that it can be a prolonged process. And because of that, DHHS and many agencies are simply opting to terminate a parent's rights with what is called a supplemental permanent custody petition, which I'll talk more about in just a moment. So that is very unfortunate. And recently it's come up in the Michigan Court of Appeals. You know, I mentioned earlier about a statutory right to counsel regarding these child welfare proceedings. There's a new question that has arisen whether or not there is a right to counsel with respect to these custody matters, because I mentioned to you about the CPLR program. The non-respondent parent is assigned an attorney through the special grant. However, the other parent, typically the respondent parent, well, always it's the respondent parent, does not get counsel. So someone took that, appealed and took that up for appellate review, and that's an interesting scenario. So we'll see how that shakes out. As I mentioned earlier, at the preliminary hearing, counsel is appointed for the child or children and respondents. In Wayne County, there's what they call a pod system, or groups of attorneys who represent children as lawyers, guardian ad litem, and which is a good situation, a good setup, because you know, there are a number of lawyers in the particular group, and there's more resources, and, you know, lawyers, guardian ad litem have the duty to visit the child or children and talk with the children by statute prior to hearings, or post adjudication every 91 days. So that's a good system that works out well for the children. I did speak about incarcerated parents. There is always an effort to get incarcerated parents involved in the proceedings. And at the preliminary hearing, rights are gone over by the jurist, the assigned jurist, which in Wayne County is a referee. Typically, I find that the case in other jurisdictions as well. But in terms of the rights, advice of rights, the assigned referee will go over the right to the assistance of an attorney at the preliminary hearing. That's MCR 3.915 B1A. There is also a right to trial by judge or jury on the allegations in the petition. There is a deadline for making a judge demand and or jury demand, 14 days, and you are held to that, believe you me. So the clock does not stop if, there's retained counsel coming in, or if there's some glitch or lag time, it's 14 days regardless. There's also the right to seek placement of the parent's child in his or her home if they're a non-respondent parent, which I just went over a moment ago, and the right to the opportunity to deny or admit the allegations and make a statement of explanation. So the cast of characters, at a preliminary hearing, again, is the referee. They are making decisions. They're going to make a recommendation as to removal, whether it's contrary to the welfare of the minor to remove the child or children. They're going to make decisions about placement of the child, parenting time / visitation. And at the preliminary hearing, there will be an assignment of the jurist of record. It will be whether the case will be going to a judge or a referee, and what the pretrial date is, the date and time, and the method of the hearing. Again, these days it's Zoom. And so at the preliminary hearing, it's all about probable cause, and it takes very little for a petition to be authorized with respect to probable cause. The standard of review is probable cause regarding one or more of the allegations in the petition being true and falling within MCL 712A to B. So many times lawyers who are representing respondent parents acknowledge probable cause. It's such a low bar. You have it. They'll weigh formal reading, they'll weigh probable cause. But typically there are full evidentiary hearings in Wayne County. In other counties, you could set another date for a full evidentiary hearing to fight the removal of the child, to fight the authorization of the petition, but it goes pretty quickly. I would say that the average hearing at the preliminary hearing level might take about a half hour, depending on the number of parents involved. It could be more, it could be 45 minutes to an hour, just depending on the number of parents involved. Also, what is addressed at the preliminary hearing is whether or not there is Indian heritage. Is the child or either parent a member of an Indian tribe? As I mentioned earlier, ICWA, Indian Child Welfare Act, and in Michigan, it's called MIPA for short, or Michigan Indian Family Preservation Act. And so if any parent, either parent says, I think we do have Indian heritage, well, then it's the job of the agency or the department to do an investigation with the Bureau of Indian Affairs. Some parents know a specific tribe, and so the specific tribe will be contacted. If not, then there will be a general investigation as to whether there might be a tribal heritage and whether the child is eligible to be enrolled into the tribe or might already be a tribal member. I myself, in the course of almost 15 years, I've had maybe 4 ICWA cases. One of them I was standing in for another attorney. So actually it was just 3 that I handled. And one of them was at the preliminary hearing level. And I did get that petition not authorized. It was knocked out. Oh, I see there is a hand raised from Professor Flores. Professor Flores, do you have a
Yes.
question?
And you
Go
guys
ahead.
don't have to be that formal. I'll have to call on you if you keep calling me professor.
Okay,
But I
Socratic
certainly
method,
couldn't
right?
call on you. I couldn't call on you with respect to this topic because I don't know anything about it. I have a non-legal question. I'm just very
Oh, sure
curious
thing.
about this. To the extent that these children are taken, quote, into custody, protective custody, but custody nonetheless, what are these facilities like? So the lawyers are going and checking on the children if there isn't a custodial parent outside of, the situation who can take care of them. What are those facilities like? I always think about that, say a little prayer about it, because it worries me that we have obviously situations where children need to be taken out, but where are they going to? I'm just curious.
Well, that's a great question, Flores, now that I have permission to call you Flores. And, it does bring up a certain subject matter that I'm glad that you raised the issue, because if a child cannot be placed with a relative, well, first I should say, if the child cannot be placed with a non-respondent parent, who under the law is really not, believe it or not considered to be a relative, but a parent. If the child cannot be placed with a non-respondent parent or a relative, then the child will be placed in what is called licensed non-relative care, foster care. And so it's not very often that a child is placed in a facility. I mean, that is like the last resort. The desire is to have the child, even if it's, a temporary placement, to be placed in a family-like setting, with foster parents. And so, in response to your question, I have performed the role of a lawyer guardian ad litem, and I've gone into many homes where children have been placed as foster children. And, they're licensed. And, I cannot say that I've ever visited a foster home that was inappropriate. Had I experienced that, certainly that would have been an issue for court.
Yeah,
Now,
Tracey.
sometimes,
Oh, I didn't want to.
Robin,
Yeah, I did want to speak to her question about what are they like. I have had some kids in the 12 and a half years that I was a lawyer guardian ad litem. I did have some kids in some residential facilities, and there were some residential facilities that were decent, and then there were some that were really, one that's coming to mind. I know I had a child that kept running away from that facility. And then there's another one where the child was running away. So there are some facilities that were not the greatest. And if they were substandard, or even placements, if there was a substandard placement, then I would report that to the court. Like I did have one, actually it wasn't a facility, it was I went to visit a child and somebody pulled out a gun, and there was an altercation in the street in the neighborhood. And I came back and reported that to our referee and the social workers, and they ended up moving that child to another placement.
right, if there is an inappropriate placement, whether it's in a foster home or, as Madam President says, refers to residential placement, then certainly the lawyer guardian ad litem has a duty to bring that issue up in court, and the child will be moved. And now there are instances where a child cannot be placed in a foster home because, here's an example, behavioral issues. And so the child does end up going into a residential placement, non-secure because the child's not a delinquency ward where they have, juvenile delinquency case. Although I will say that in some of these cases, you have a dual ward situation where the child is not only, well, I'm talking about what is called pre-adjudication before the parents have been adjudicated, but you have cases in family court where a child ends up being a dual ward as a neglect and abuse, ward. And also they may have caught a delinquency case. So, but Flores, again, to your question, to your point, residential facilities, some of them are pretty good and some of them not so good. And as Robin indicated, if they are not, it's a very serious issue. I don't mean to make light of it, but the bottom line is if they're not appropriate, it does become an issue and the child will be moved. So yeah, sometimes there are, issues in these facilities as to bullying and what have you, but for the most part, in my experience, I haven't had any issues with any of the foster placements, in-home placements, or residential facilities. I hope that answers your question.
Yes, thank you.
Great. Okay. And Monique Jordan has her hand raised. Monique?
Hi, yeah, I have a quick question.
Sure.
A lot of times, that the homes are not in bad conditions, but because of the system, they want to just take them out because they are Native American children. Is that being addressed as well?
Good question. Oh, I'm glad that you mentioned that because at the preliminary hearing, if a child is found to be a Native, tribal child, indigenous, then the tribe will be invited to intervene, to participate. And the matter that I handled on the preliminary hearing that I got dismissed, the tribe did intervene. And so we did tag team. In this case, it was MDHHS, and I really don't know why the petition was even brought. It was for temporary custody, not for termination of parental rights. But the mother in that particular case was a victim of domestic violence, but she did everything that she could have or should have done when faced with that situation. The child, she was a member of a Michigan tribe. The child was not within the hearing of the domestic violence. In fact, wasn't even at home, was 2 doors away. The mother called the police. The mother went for domestic violence counseling. She did everything that she was supposed to do. The child wasn't harmed or injured. So that case went bye-bye. Yeah, it got knocked out. The referee agreed with the tribe and myself that the case should be dismissed. The petition should be not authorized. And so that is what happened. Now, I'm not sure I answered your question though, Monique.
You answered part of it.
Okay.
The other part is it's been a uprise of a lot of times just taking them out for simple things and adopting them out, or not even giving Native American or the tribes to have their own children. And so that's been an issue.
Right. So I'm glad that you raised that point because, if a parent or parents are facing a temporary custody petition, the department or the agency, has a duty to show that they made reasonable efforts to keep the child in the home and to keep the family intact. That's not the case with PC, permanent custody. The department or the agency doesn't have to show reasonable efforts. But if it's an Indian child enrolled in a tribe, then the department, meaning MDHHS or the agency, the assigned agency, the standard raises to active efforts. And in terms of removal of the Indian child, the standard goes up to clear and convincing evidence at the preliminary phase. So I have some resources for you that I'll talk about at the end But the bars are high when it comes to Native children and Indigenous children. And that's why what's happening at the US Supreme Court with ICWA is, has some serious consequences. But one thing that Michigan can be thankful of is that, or for, is that Michigan is one of just a few states that have actually codified the Indian Child Welfare Act. We have MIFPA. So even if ICWA were to somehow get struck down on the federal level, we would still have it here on the state level. So not to fear, Monique, with respect to that. But yes, there is a history of removing Native children from their tribes, from their families. And that's what this case is all about that we're going to talk about in just a moment. And the Indian Child Welfare Act, was instituted in 1978. I think that's like 44 some years. And there's this case up at SCOTUS called Burkeen versus Hallen. There's Deb Hallen right now, right here in this picture. She's a U.S. Secretary of the Interior, and she is a Native woman. She made history by getting that appointment. SCOTUS took up the case just this past November the 9th. And, Burkeen deals with 3 states in particular, Texas, Indiana, and Louisiana. Sorry for that typo there. And basically the individual plaintiffs who are non-Native people, for the most part, sued the federal government, and they are arguing that it's an equal protection violation and also a violation of substantive due process under the Fifth Amendment and the 10th Amendment. And so the crux of their argument is that it's a violation of equal protection because tribes and Native people are getting a preference for Indian children. And so this is a fascinating case. It's really sounds in tribal sovereignty. Tribal sovereignty is really at stake. And I pulled an article earlier. Some of the things that are at stake, in addition to the Indian Child Welfare Act being struck down, is that it could have impact on the viability of the Small Business Administration's 8A program, Bureau of Indian Affairs hiring preferences for Native peoples, a number of federal legislation that provides benefits to Native American tribes, like the Indian Self-Determination and Education Assistance Act, and tribal sovereignty, which in a nutshell means that any law that grants Native peoples, including Alaska Natives or Native Hawaiians, a preference would be on shaky ground if this Burkeen case prevails at the US Supreme Court. And the SCOTUS is expected to make a decision in June of 2023 at the end of the court's current term. So everybody's going to be watching that case closely. There has been pushback on this. I've been tracking this case, and there was a big rally out in front of the US Supreme Court. There were a number of tribes out there. They're doing dances and demonstrating, and 497 tribes in 24 states and Washington, D.C. are defending ICWA. There have been a number of amicus curiae briefs that have been filed, and they just want to ensure protections for Native American children. We've all heard about what has happened to Native children and being taken away from their tribes and family at these Indian boarding schools and forced assimilation. Well, some could say, the same thing has happened for Black children as well. But the reason why, the Indian Child Welfare Act has occurred is because of, these federal treaties. And really, there is an argument for standards of proof being raised for Black children as well. And that it should go to active efforts, in my mind, for all families. Really, I do believe that it should be active efforts and clear and convincing evidence. And if a family is facing permanent custody petition where the parents are facing termination of parental rights, I believe it should be beyond a reasonable doubt in terms of the evidentiary standard. Right now, it's clear and convincing as to statutory grounds. So this is a case to watch closely, Burkeen versus Hallen. Monique, did you have anything else, or is your hand just still up?
Oh, my hand is still up, but I did have a question.
Sure.
To doing this because that was one of my concerns about the adoptions and taking them out, and the whole purpose is to water down their tribes, and so and they want to, they're already been a lot of them are gone as it is, a lot of different tribes. So I'm just glad something is trying to be done for this.
Yes, thank you for your comment. And, back to the preliminary hearing, one thing that I should mention is that, whether you're representing parents or the child or children, it is important to go over that petition with a fine-tooth comb and make sure the court is supposed to do it as well. And we'll ask questions at the preliminary hearing, but I always ask whoever I'm representing, if it's a child who's too young, certainly you can't ask the child. But if it's an older child, yes, you can ask if your name is correct. You can ask the parents the same. The phone number, they don't ask for email addresses, but I think maybe they should. If the citation to the section of the juvenile code relied on is included, whether the R is noted on the petition in the appropriate box for the appropriate parent, R meaning that the parent is a respondent, and the type of relief could be reviewed. If I'm representing parent or child, I let them know what a preliminary hearing is, what's going to happen. We'll talk about placement of the child. Sometimes at the preliminary hearing, the child or children have already been removed, but sometimes they haven't, and that's where, contrary to the welfare findings, will be made and the child or children will be removed. But not all the time do children get removed at the preliminary hearing too. Sometimes the department of the agency decides not to remove the child. In Wayne County, there's what they call a special docket called baby court. They also have another docket called the resolution docket. And I found that sometimes DHHS does not remove the child or children because they don't believe that the child, even though their parents are facing a petition, that the child or children is at risk of imminent harm, so that the child or children stay with the parents, interestingly enough. So that is what happens at the preliminary hearing. And it's very important to make sure that parenting time is set up, with the exact date, that who the assigned FCW or foster care worker is. If there are siblings across different placements, that sibling visitation happens. That is so important for maintaining that important bond as well. And then you find out where you're going in terms of your pretrial. Are you going to a judge? Some families have had a prior case, and there's the concept of one family, one judge, and so the family may be going to a judge automatically or to a referee, and so you will find out where the pretrial will be held in terms of the assigned jurist of record and the date and the time, of course, and usually it's the attorney who lets the client know how to access Zoom, because in Wayne County anyway, there really aren't any paper notices anymore. So unfortunately, and so that leads us to the pretrial phase. And the big question there, pretrial, is to plea or not to plea. And so if it's a temporary custody petition, where the department is saying, oh, the family needs an intervention, the children need to be made temporary court wards, and then you were unified with the parents. Sometimes at the pretrial, the parents will just make admissions. And so the question becomes, what type of admission will they make? Will they stipulate to the petition and make admissions as they appear on the petition? Or if a parent or parents are facing criminal child abuse charges, you may want to do a no contest or a nolo contendere plea. And so the parent will or parents will not make specific admissions. They'll just do a no contest, and there has to be a basis for that, avoidance of any potential civil or criminal liability. And there has to be a factual basis for a no plea or no contest plea. And typically in Wayne County and in other jurisdictions, it is a CPS investigation report, which is referred to as a DHS 154, redacted. And I remember earlier in my career at juvenile court, there was this blanket approach to the DHS 154, but now the lawyers should really carve out a specific area of that CPS investigators report or investigation report to be a basis for a no contest plea. And now that's a shortcut. Many times if a parent is just facing a temporary custody petition, and I don't mean to minimize it in any way, shape, or form, but certainly temporary custody is better than permanent custody. A parent may want to take a shortcut and do a plea and jump into a treatment plan, a parent agency agreement and initial service plan, which typically consist of individual therapy, maybe family therapy, parent education course. If substance use is an issue, they may have to do first a substance abuse assessment, and they may need to do random drug screens. Typically, it's suitable housing and maintenance of that and legal income, as well as attend all court hearings and contact with the assigned foster care worker. Sometimes if parents are having issues with housing, which frequently they are, not only in Michigan, but all across the United States of America, in Wayne County and in other jurisdictions, specifically Oakland County, I know they offer a parent partner program, which can be invaluable because the parent partner is typically someone who's been through the process successfully, and they can give pointers to the parents. And what is really helpful is resources for housing. They can help the parents get on lists and obtain Section 8 housing, but those lists are long and the odds are long for winning the Section 8 lottery. So housing is just such an issue in America, as we all know. And just because a parent cannot locate housing, that really shouldn't be a sole basis for a temporary custody petition. Now, if a parent or parents are facing a PC petition, that's termination of parental rights. Sometimes, believe it or not, parents will stipulate to the petition. I served as guardian ad litem on the case against Michelle Blair, who was known across America as Freezer Mom. And she had faced criminal charges or was facing criminal charges. And basically she was like, yeah, I did it, while she did not stipulate to the petition, she could have. She really didn't have the capacity to stipulate to the petition. That's why I was on the case as guardian ad litem for the mother to assist her principal counsel with that case. But sometimes parents will stipulate to statutory grounds regarding permanent custody. And the reason why parents do that is not necessarily because they want to give up their rights to their children. In In neglect and abuse cases, child welfare proceedings, there's another part to the trial called best interests. And frankly, sometimes while a parent might admit to statutory grounds, they could win on best interests. And that's a separate hearing to determine whether it's in the best interests of the children to terminate the parental rights. Yes, maybe the parent did do abuse or neglect, but because there may be a very close bond, because the child's in relative placement, that it's just not in the child or children's best interest to terminate. So back to the list here. At the pretrial, if it is going forward to a full-on trial, even though the law has changed, and in Wayne County, it's the Attorney General who is representing MDHHS and or the agency. They have a duty to supply discovery 21 days before the trial. I always ask for a joint pretrial statement, which is mutual discovery. And there might be a statement from the child. You may have to go see the kids talk interview. Well, nowadays it's all on Zoom. You just set it up with the Attorney General's office and you can see it right from your desktop, which is good. We can thank the pandemic for that. But I still ask for a joint pretrial statement, even though, the burden is on the Attorney General to get that discovery to you. I always ask for mutual discovery. And there could be some pretrial motions. And then it's decided whether the trial will be heard before a jury, a judge, or a referee. A parent can make a judge demand. For PC cases, I typically always make a judge demand. Not always, but typically I do. Jury trials, I have never, in the course of my career, had a jury trial regarding a child welfare proceeding. Some parents who have retained counsel might opt for that. I have found that juries in many ways could be harder on parents than a judge or a referee. So that is rolling the dice in terms of a jury, but they do happen, and that demand has to be made. It should be made sooner than later. As I said earlier, there's a 14-day cutoff. If there are incarcerated parents or clients, then in Wayne County, we call it a ready for trial. Arrangements have to be made. I always put it on the record if the court could please ensure that my client will be made available for the trial. We confirm where the parent is, whether, they are confined on the state level or in a jail or in a federal facility. They've got to be there. And we did talk about admissions versus the no contest plea. So in the interest of time, it's 4:30. Sorry for being a little long-winded here, but then we move on to trial, and there are different evidentiary standards. It's preponderance of the evidence. If the parents are facing a temporary custody petition, we know that is a very low standard or burden of proof. It's clear and convincing if it's a permanent custody petition. It's beyond a reasonable doubt if it's an Indian child. The burden of proof increases, and the rules of evidence apply at trial regardless of whether it's a TC or PC. However, the rules of evidence do not apply at the preliminary hearing, and they do not apply at disposition or what we call DRH PPHs, dispositional review hearings, permanency planning hearings. That's after disposition. So that's the difference between a temporary custody petition and a supplemental PC trial. Now, of course, at trial, it's so important to develop a theory of the case. It is important to call supporting witnesses, to cross-examine the department or the agency's witnesses. Yes, you can ask for a directed verdict. I've never seen one happen, frankly, in Wayne County or anywhere else that I practice, and I practice in 8 different jurisdictions. It is important to get expert witnesses. I have hired a number of expert witnesses for indigent clients, and the county has paid for them. I filed a motion citing N. Ray Yarbrough to the chief judge of Wayne County Court, and I've always gotten money for expert witnesses, typically for what they used to call shaken baby cases. But the bottom line is to prepare, knowing that case backwards and forwards, not doing what one of my colleagues from the Attorney General's office calls a drive-by. Okay. You have a drive-by trial. You have to prepare and know that case like the back of your hand. And I alluded to earlier the best interest hearing. That is really, 2 bites of the apple, because a parent may be found to be liable, frankly, for one or more of the allegations as to statutory grounds. But is it in the best interest to sever that bond between that, I should say, legal relationship between the child and the parent? And so that happens at a best interest hearing, and the parents are entitled to an opportunity to present evidence regarding the child's best interests. And frequently there is a focus on the bond between the parent and the child, how the parent, how often the parent has visited the child, and the interaction between the parent and the child at visits. That's why that is so important. And that would happen prior to the court rendering a decision regarding whether termination is appropriate. Now, sometimes in Wayne County, there's something called a clinic evaluation, and parents can speak with a clinician. Typically, it's a social worker about their case, and the clinician will make a recommendation about whether they feel that it's in the best interest of the child to have the parents' rights terminated. That could be a roll of the dice. You don't know which clinician you will get and how the clinician will feel about your client. But the bottom line is the court does not have to adopt the recommendation of the clinician for or against. Sometimes I will say, yes, I want a clinic evaluation for my client. And then sometimes, you don't really have any control, because the Attorney General will ask for a clinic on behalf of your client, but the client doesn't necessarily have to show up. And sometimes they don't show up. And that isn't necessarily going to go against the client either. So, and so then moving on, in the interest of time, if you disagree with the assigned jurist, whether it's a referee who is going to make a recommendation to the judge, you have the right to referee review under MCR 3.991. It's basically a form, 1-page form you can fill out. I've seen parents fill out the 1-page form, frankly, and do a review on their own because they disagree. Or you could request a rehearing or reconsideration. I know that Attorney Rita White has developed a great reputation for filing successful motions for rehearing or reconsideration. A judge recently complimented her on doing so, and kudos to Rita White for that. That's under MCR 3.991B and MCR 3.992. I myself, I've never done that. I will admit, I've never done it. I just go straight to appeal. I am a trial attorney. I do not handle appeals, but what I do is I assist my clients, who 9 times out of 10 are indigent, and I've been assigned to represent them. Sometimes I have handled retained cases, but if they are indigent, then I do assist the parent, with filing a declaration of indigency and a request for counsel, which, by the way, I failed to mention that at the trial phase, the jurist of record, whether it's a referee or a judge, should be giving the rights, the appellate rights, the rights to review, and that gets us to this slide. So appeals under MCR 3.993A1 and MCR 3.993. And if a parent applies for it, you can do it all by email. I do assist my clients with that. I had something interesting happen to me just a couple of weeks ago where twice this has happened, where a parent wanted to appeal and then they wanted to withdraw the appeal. And I really got into it with counsel for Wayne County about the withdrawal. And we actually ended up having a Zoom hearing in front of a judge regarding the withdrawal of the appeal. But we did put it on the record, and the parent was allowed to withdraw the appeal. And so then we get to the initial dispositional hearing, which is conducted to determine what measures the court will take with respect to a child properly within its jurisdiction, and when applicable against any adult, once the court is determined after the trial or plea of no contest that one or more of the statutory grounds alleged in the petition are true. That's under MCR 3.973. Michigan rules of evidence do not apply at the dispositional hearing. I touched on this a little earlier. Basically, the parents are going to get a treatment plan, a case service plan, a PAA, which stands for Parent Agency Agreement, and an initial service plan. The foster care worker will be present at that point. They'll take over from the CPS investigator and the petitioner, who's typically the petitioner. If they're from the Michigan Department of Health and Human Services, you also have agencies out here who are petitioners as well. And, there's a role for advocacy there for parents and children. There are things that children need at the initial dispositional hearing too. They might need a trauma screen. They might need a trauma assessment. They might need an IEP. Sibling visits should be ensured. Parents, as I ran down earlier, typically they're going to be required to get individual therapy, maybe family therapy, parent education. They have to show proof of legal income. They have to show proof of suitable housing, contact with the worker, attend all court hearings. They might end up getting a parent partner to help them with housing, and they will be given about 15 months to complete that treatment plan. I have seen parents do it in record time. I had a case that resolved recently, and the parents flew right through the treatment plan in 6 months' time and were reunited with their children. And it was a PC, permanent custody petition. We did not go to trial. I did hire an expert in the case, and both parents ended up making admissions. But you see, it because of the best interest portion of the trial, of the adjudication, it was not found to be in the best interest of the children in that particular case to sever the parent-child relationship. I did ask for a clinic evaluation in that case, and the clinician did render a favorable opinion to both parents. By the way, the parents were going through a divorce as a result of that case. Did involve alleged physical abuse. I represented my client in the divorce case. The parents ended up reconciling, so the divorce matter was dismissed, and happily the parents were reunited with both children, and that case closed just a week or so ago. So it is important to always get, well, let me back up. Many times the foster care workers do not have a written case service plan at that initial dispositional hearing. Sometimes they do, but many times they don't. And so it'll just be put on the record orally, but it must be signed by the respondent parents ASAP. Many times jurors will put a deadline on it. And you should get a copy for the file. I always ask for email copy. And that is the anatomy of a child welfare matter in about 75 minutes. So thank you so much for inviting me to present to you today. Madam President, I invite any questions. There are some resources here. I did want to mention this one hot case. It's called NRA MR Simonetta. That's about the maternal use of marijuana. We know that medical marijuana and recreational marijuana are both legal in the state of Michigan. However, it is many times still used against parents, and the MR Simonetta case talks about a respondent parent's prenatal use of opioids and marijuana. That's interesting. I just realized that it was opioids and marijuana. My focus in the past has been marijuana. And so this was heard by the Michigan in the ground of whether the child had been subjected to aggravated circumstances, specifically severe physical abuse. And basically, the Michigan Court of Appeals said that a prenatal exposure to marijuana is an aggravated circumstances. So it's not per se child abuse, because interestingly enough, the child's a fetus prenatally, not a child. You might want to check out that case, but I have argued this in Wayne County with much success, not so much success in Oakland County at all. So that shows you the difference in jurisdictions. Also, I did want to mention to you something that the State Court Administrative Office makes available online, judicial bench cards. You might want to pick one of those up. I mean, I actually was referring to it at times during my talk today. A lot of great information, excellent cheat sheet, jurists use it all the time. And, I was prepared to come and see you and present in person today, and I was going to provide some materials, but if anyone would like to contact me for additional resources, for example, I have the Foster Parents Guide to Court. I'm sorry, I'm using a green screen. You might not be able to see that. And the Child Protection Pamphlets, as well as some other resources for parents who are facing either temporary custody or permanent custody petitions, resources like parent education classes, because even though the parent might be facing the permanent custody, risk of termination of their parental rights, if they jump in and start doing their own services because the department or agency isn't obligated to do that, that can really make a difference. It can really make a difference. So thanks again for allowing me this time to present to you today. Thank you for your questions. And I'd like to wish you all a happy Friendsgiving. I celebrate Friendsgiving or Thanksgiving, whatever you celebrate. The concept of thanks and giving thanks, I think, is very worthy and valuable. And so thank you for giving me this voice today and this space to speak with you. Thank you.
Tracey, I want to thank you for this awesome presentation. This has been great. And I did have a question about the Supreme Court, because I had heard about that on the radio. Do we have an idea when they'll be giving a decision? Will it be in the spring, or will it, do you know when they'll be giving it? It'll be June.
Yes, at the end of the term, because as you know, it's a very, thank you, Mary. Thank you for all the feedback. Yes, Investigator Phillips, Mary Bowens, Professor, I got to give you your, kudos, Professor, you earned it. So Professor Flores.
Thank you, I appreciate it. I just don't like to be formal outside of the classroom or in front of students.
Okay, Flores. Gotcha.
Thank you.
Sure.
It's not that serious.
Got you. Okay, but it's June 2023. That's when they're going to give their decision. Yes.
Okay, and then I just want to let folks know, because this is a speaking series, we are giving CLE credit. I did put down the BWLAM CW is the credit for this program, and I did put together a certification form that if you, and I recorded who was present, so if you want that form, then just send an email to the BWLAM@michigan.org. I'm just putting that in the chat right now. That email. And Tracey, this has been great. On the issue about you raised about trials, I did some trials in Washtenaw County on parental discipline cases, and I had success. I find Wayne County is kind of different. I know Troy Tipton has done some trials on the neglect cases. I find that Wayne County actually seems, from my experience in the jurors that I was in front of, that you actually had parents that got more time to get their act together, as opposed to it was like a faster track in Washtenaw County. So I don't know. I guess it depends on what jurist you're in front of. But yeah, this was an awesome presentation. And thank you for your expertise.
Robin.
Go ahead.
Yes, well, thank you again for inviting me. But I just, as an aside, to your point, I attended the Juvenile Trial Lawyers Association of Wayne County event on Wednesday with Attorney White. And one of our members, I'm a board member, and Rita, I don't know how she does it, but she's also an officer with Jet Law. We call it Jet Law for short. She's also an officer with Jet Law too. And one of our members who's leaving to do strictly appeals with Max, is very talented, by the way, told me that she has been representing a parent for 7 years, that the case has been going for 7 years. She just kept, getting more time for the parent. And one thing that I didn't mention earlier is about, the supplemental, I think I touched on it, but the supplemental PC petition, she handled several of those and got the mom seven years. And, the thing about this particular mother is that, in her words, she just was overwhelmed because she had 10 children and she really didn't have that much help. 7 years. The case went on. So I agree with you. I say all that to say I agree with you. In Wayne County, yeah, you can get a little bit more latitude depending on the jurors. So I practiced out in Oakland County, on that family and juvenile court docket, and it's a little different, but yeah, again, it just depends on, each case is different. It's a case-by-case situation. So thanks again.
Yes, and I do see a hand raised from Rita. Rita, did you have something to add? Rita, or maybe that.
Yeah.
Oh, go
yes,
ahead.
You just heard from one of the most talented practitioners, litigators, child welfare attorneys in the state of Michigan, Tracey Martin. She is very good. I practiced before her on many occasions. She's very learned. So please, I agree. I hope Attorney Martin joins in with me with really, if you are interested in working in the child care arena, I would highly, highly encourage it. We statistically, the majority of individuals, parents that are in the system are minorities, specifically African Americans, especially in Wayne County. What we need to do is we need to make sure we have more representation. And Black women lawyers, I think, are very pivotal in terms of being in a very good position to represent parents. Because what me and I know Attorney Martin will agree with me, and I know there's several other attorneys that practice child welfare in this screen right now, is a lot of families slip through the cracks. We have to be there to make sure we address cultural competency and make sure these parents and these families are maintained together, because one factor is the courts order Department of Health and Human Services and the foster care agency to exercise reasonable efforts to reunify the parents, most of the time, unless it's a permanent custody petition, meaning they're in a position that the department or agency cannot exercise reasonable efforts due to aggravated circumstances such as sexual abuse, physical abuse, etc. But a lot of times when you have these type of cases, you do not see that happening. and we go through review after review and wonder and figure out why isn't there any progress with the parents. And a large part of the reason is because the agencies are not assisting the parents at the standard level they are supposed to. So we as African-American Black women attorneys really need to get and more involved in the child welfare system, and really hopefully start getting more and more involvement in representing parents so we can maintain our families and our community and make sure they're being adequately represented and adequately serviced in the community so they can be reunified with their families. Because we have more, unfortunately, there's a lot of terminations and parents not being reunified with their children as opposed to reunification going forward. So I would really, 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 really encourage anyone who has interest in really helping our community in that aspect to get involved and just meet with either me, Attorney Martin, Attorney McCoy, or any of our attorneys that practice in this area to try to get involved in the child welfare system and representing individuals.
Yeah, and I would say, yeah, for me, because my background, I started representing parents, and I represented kids, and I did kids exclusively. Now since 2019, I'll do like retain for representing parents. But one thing that I kept in mind as a lawyer garden ad litem is I think it's important that it's if you have that background, having represented parents and being cognizant of the fact that there are a disproportionate number of African-American families that are broken apart, and just having whether you're representing parents or the kids, having that having some compassion for the families, because there are situations where the kids should not necessarily be taken out of the home. Like there's resources that can be given in the home to maintain that family, because there are some situations. I mean, there's the flip side. I have seen some really traumatic ones where I'm like, okay, no, that there's some severe sex abuse or physical abuse, then yeah, the kids need to be taken out of the home. But you have the situation where if some of these kids are taken out of the home and they're put with strangers, and they might get sexually abused or physically abused. They might be in a worse off situation when they're taken out of the home. And then I know in Wayne County, they have the aging out programming, where you have kids that age out of the programs, and then they get caught up in the criminal justice system. They're homeless. So sometimes it's better to just give resources in the home than to rip the kids away from their parents and just throw them. You're basically like throwing them to the wolves. And then Rita and I both do adult cases, criminal cases, and you see people who you talk to them about their background, and they talk about they've been in the neglect system or the delinquency system, and it's a cycle. It can be, and it can be really, it's a really bad situation. So Tracey, I thank you for coming and speaking to us about this topic. And, we got about 3 minutes left. I do know that we have, I want to make sure everybody knows we have the cocktail sip that's going to be on December 15th at 6 o'clock. So pay attention to your emails or social media about that. And we have Wendy Barnwell will be coming and speaking with us in January about how to handle a criminal case. And then we have our own attorney, Rita White, that'll be coming and talking to us in February about how to handle a delinquency case. So, and again, the code for this session is BWLAMCW, standing for child welfare. I don't know, did anybody else have any other questions? Or Tracey, did you have any other comments?
No, I agree with everything that you said, Robin and Rita White. I just really appreciate your appeal for younger lawyers, newer lawyers to get involved, because this really is a very niche area of the law, believe it or not. And I don't see a lot of newer attorneys coming into this area of the law for some reason or other. So I thank you for this opportunity to present today in hopes of, drumming up some interest in getting into child welfare law, whether it's Wayne County, Oakland, Washtenaw. One thing about Washtenaw County is that I, find that they are very sensitive to issues of domestic violence, and kudos to Washtenaw County for that. But yes, I practice in a number of counties, and there just aren't a lot of lawyers in this area of law. So I hope that our newest members of the bar will consider practicing in child welfare law as Attorney White so passionately advocated for and appealed to you earlier today. Thank you.
And I'm sorry to interrupt, but I'm a little under the weather, so sorry if my words are slurring. I have this weather, this temperature has really changed, has really messed my immune system up. But what I would also is prevention, prevention, prevention. If you see a family at church, if you know a family in your family, if you know a family anywhere, just be mindful that when a petition is filed against a family, they are automatically placed on the registry, the child abuse registry. And you don't, no family wants to have any type of label or any type of stigma or anything that may affect their employment. So what I would suggest and encourage is, even if you do not practice in this area, please, by any means necessary, help to provide assistance if you flag any issues with a family or family you know, like referring them to an attorney to help prevent any type of petition being filed against them. Because that's what we really need to focus on. We don't want all of our families in the system based on issues that could be prevented outside of the system. So that's just my last note. And I extremely thank you, Tracey, for putting on this presentation. It's very much needed.
Yes, and I mean, I definitely caution parents about talking to CPS because, you know, from what we've seen in the neglect system, they take what you say, it's in a petition. It's just like with the criminal court, and I tell people to talk to a lawyer first. So I would say to parents, talk to a lawyer first before you just engage with CPS, because you just, you know, you look up everything you've said is in the petition, and then you're looking at it could be temporary custody or it could be permanent custody, and you're looking at losing your kids, and you know, I've even had some cross cases. I know Tracey may have had some too in family law, where you have it where CPS is called and it's a family law dispute, and I've had to talk to CPS and let them know that it's really a custody case. It's not a CPS case, but some parents will abuse the system. They try to get CPS involved as ammunition in the family law matters. So there is some overlapping. Okay, so it's 5:01. So everybody enjoy the Thanksgiving, Friendsgiving holiday. And we won't be meeting in December, so look out for our next meeting. Will be in January. If you have any ideas, make sure you send us an email at the bwlam@michigan@gmail.com Gmail, and everybody have a blessed day.
And I would like
Thank
to make
you.
a motion to adjourn the meeting.
Yeah.
Have a beautiful week and holiday, everyone.
You
Yes,
too.
everyone.
Nice
Bye-bye.
to see you. Bye, everybody. Happy Friendsgiving.